Welcome back, everybody. This video is about the Anchorage Assembly trying to pass an ordinance to trespass the homeless from public property. They've even gone a step further than that. They've decided to arrest homeless for trespassing on public property. You heard me right. Public property. Parks in the municipality of Anchorage. This is crazy. In this video, you're going to hear council members argue on both sides. You're going to hear two Anchorage police officers, and I'm going to play a short video from Anchorage Assembly member Keith McCormick. Let's get into it.
Anchorage is in an abusive relationship. And like too many victims, we keep making excuses. We say it's complicated, we say things might change, but our parks are overrun, our trails are trashed, our playgrounds aren't safe, and the city acts like it's normal a mom can't bring her kids outside without the fear of being accosted. This isn't just a housing crisis, it's a safety crisis. We've lost control of public space, and it's getting worse. That's why I'm introducing a prohibited camping ordinance. We have to start somewhere, and that means drawing a line. Public comment is June 24th. If you're ready to take back our city, show up and speak up.
Live stream? Is this a homeless meeting? Well, it's not a homeless meeting. It's a work session. Yeah, thing.
So that's perfect.
If I could just follow up for that, Mr. Chair, and I'd like to ask if you can follow up, because it is a three-step as well, and it goes to Mr. Buson's comment about the goal is compliance, not arrest. And so there's a three-step when APD is engaging with an individual and what they already are doing. And so Lieutenant, can you talk about when you are encountering and engaging now with an individual, the steps that you or AFD would take?
Yes, ma'am. Thank you for that. And to the Assembly, to the Chair. So Brian Peaks, I'm the lieutenant over the whole team at MIT. And so a good thing here to point out pretty quickly is the fact that out of all the abatements and all my time as the leader of this team, we've made no arrests during the abatement process, or actually that I can think of through the trespass process to have people relocate from a specific zone that they either aren't allowed in or shouldn't be in. My team has taken excessive steps to ensure that we get some level of voluntary compliance. And that goes to what the chief was talking about using regionalness in these processes and looking at the situation in its totality and providing a level of kind of the human approach, saying, okay, like, we can't make you leave in an hour because there's no human possibility that you could move all this stuff in an hour. So how does that work? And spending the time and working with those individuals. So just want to put that on the record, and I do put that, I do understand, to your point, I work specifically with therapeutic courts. The attorney actually meets with my teams, and we work with the courts extensively. I understand the capacity, and your point is taken. I understand that, sir. So, officers, I would just offer that the argument we never arrested anyone is not an argument passed in the law. It's counter to the argument, but I still look forward to hearing this.
And I don't bring it up to that. I'm just letting you know, operationally, we can do a lot. And we are doing a lot. So when we have contact with somebody in a camper that's potentially violating an ordinance, whether it's trespassing or camping, officers will make contact with that individual and seek voluntary compliance. That's usually a conversation. You can't be here. These are the reasons why you're not allowed to be here. These are your options, right? You can leave this area. It's a complex case. If it's a case that involves behavioral health or potentially a resource issue, those individuals can be contacted, like Hope, CAP, to then try to get individuals to connect with those campers. And Hope doesn't have to be present. They do a lot of consulting over the phone. So does MIT. If someone needs a clinical consultation, they can get on the phone with a clinician, one of my clinicians, and talk directly to that individual. We also partner with MCT, and MCT, if it's still can get out there, it's safe to do so. So we do provide those kind of resources in some situations, not in all situations, because not all situations are the same. but they are given the opportunity to leave the area. Now, if that individual decides that that person, they don't want to comply, and we've given them a legal reason why they need to comply, then we can facilitate an arrest on an individual. Most people don't know this, and the first arrest is generally a citation. So we issue them a citation. It's a piece of paper with a court date for most misdemeanor arrests outside of person's arrest. We'll give them that court date, and they'll have to leave the area, right? If they come back to that area, then they could be charged with violating those conditions of release that we provide to them once we give them their court date. So there is multiple steps that we go through before they actually are remanded into a detention facility. So there's multiple avenues and layers that we can provide assistance, that we can provide outreach, and that we can give them the opportunity to make better decisions.
I agree, and I really appreciate that. I'm going to let Mr. McCormick jump in. Q, because he has to be very short. Q, go ahead.
Yeah, thank you very much, Mr. Chair. My one question to the administration is when I look at the map and I see the outline of where this will be enforced, I see private property, a lot of private property in there is kind of in the unprotected area. Is any consideration being given to residential property?
For the chairs, with something that I'm calling, for private property, trespassing private property is already defined, and APD is enforcing it.
Is there any standoff though? Like a camp could be built on the back of somebody's fence?
So the AO here, again, through the chair to the member department, the AO here is focused on areas of high priority, right? So we're talking about schools, playgrounds, on streets, on sidewalks, within 200 feet of our trails, within 200 feet of high-speed roads. And as for on snow dumps, the athletic fields, as for those high priority areas, that's what this AO is targeting to give us additional tools for a swifter response to prevent entrenched encampment. This AO does not alter all of our other available tools, including civil abatement. To the contrary, it actually makes civil abatement more efficient. To the extent we can prevent entrenched encampments and deter people from camping in these sensitive areas, then we can focus our abatements on other areas and protecting public lands outside of the areas identified in this AO.
Perfect, thank you.
Thank you. Mr. Ryan.
Yeah, thank you, Mr. Chair. So, 3 questions for me. And first, I will apologize. I have to leave a little bit after 1:40, so in about 15 minutes. So, first one is, and I'll just ask all. So, first one is around this issue of APD enforcement. So, if what we are looking for is compliance and not arrests, then I guess tease that idea a little bit for me. Why do we need a new law to deal with compliance? So that's first. 2 is around provider integration. How does this ordinance and the various other processes that will come after this ordinance look at provider integration? It's hard for me to imagine a scenario where if you don't integrate our service providers into all of these processes, that's going to lead to very positive outcomes. And then third is, how important is having a place to be to making this ordinance actually work? Because if we are saying this is where you cannot be, then people need some place to be. And we know that our shelters are more or less at capacity. There's not as many housing units as we need. We know all of these structural issues. So how important is having a place to be to make this work, and what are we doing on that? Thanks.
Through the chair, I think we will have Mr. Busa answer the first question and Ms. Brown answer the second 2.
So through the chair to Member Rivera, thank you for the question. The question was, why is this new law necessary to obtain that swift compliance we're looking for? I think you can see the answer in looking how burdensome and difficult procedurally it was for the administration to accomplish the 28 civil agencies to accomplish this past year. It involved a large amount of coordination from large teams of people, a lot of preparatory work, and a lot of very costly work on the back end. Here I have in mind the Spartans where some of the details long notes do so. I believe that the information I have is that the total trash collected out of Davis Park and the snow dump as of the 8th of July was 744,000 pounds of trash at an expense of 1,914 person hours. And that's because obtaining compliance there was quite difficult after that camp became entrenched. And also the civil aid process again requires that 10-day notice period. And when camps become entrenched, the cleanup becomes quite difficult. The goal with this AO is to have another tool in the toolkit to prevent that kind of entrenched camping. So imagine someone comes and a first tent appears too close to a playground, a school, another sense of area, a high traffic road where you don't want any pedestrian deaths. APD now has a tool to come along and say, listen, it's now actually probably prohibited to camp here. I'm going to give you a reasonable amount of time. You have to start complying right now. And you have to pick up, you got to move on. We're not going to tolerate entrenched encampments in these dangerous areas. It's the potential threat of a criminal consequence if they don't start complying right then that we think is going to obtain us with compliance.
Others don't answer the question.
Through the Chairman Rivera, with regard to provider integration and a place to go. I think you've heard from Mr. Musa and from other members that we have really been setting the table to move towards having a balanced approach to enforcement, shelter, and support. As APD identified, we have a primary team, MIT, CAB, as well as our ECT that would be really primarily engaged. APD has discretion. We really are looking towards having compliance. Because we have a select group of players that would really be enforcing and supporting this work, we've had time to build those relationships to link to shelter and supports. Outreach has been a critical component of all of the work that we've done, and our CAP team has led the charge in really supporting and highlighting that throughout the last 1 year of the administration's work. That work includes being able to pick up the phone and call our outreach workers when they're engaging with someone. We often see this when there are individuals with behavioral health conditions. NCT has a close working relationship with our shelter providers as well as our shelter coordinators so that we're linking individuals. What's very different this shelter season is the level of coordination, so that if we do have East 56th Avenue is full, how do we pull our providers together to say we have a vulnerable person, where can we make space? That also includes, and very thankfully, we've had community providers that have made funds available for rooms. So what we're able to do is incredibly different, and again, has set the table for our ability to be responsive while keeping that dignity and respect for the person right in front of us. So I will be as transparent as possible. There are going to be times where someone may walk away and say that there's no shelter available, but our officers have always and will connect and try to link them to shelter when that's available.
I know you have, so I'll do this here. All right, let's just see the opportunity. So I guess the one follow-up I have, and thank you, Mr. Allen, for that, is, so, I mean, essentially, are we going to be relying on police officers to provide that integration to providers? Or are we going to have providers that say, you are going to use this ordinance to evade to seek compliance? And are you going to then call a provider and say, hey, we are seeking compliance at this encampment? Can you have providers outreach go out to that encampment? I want to know what is that level of integration?
Through the Chairman Rivera, with the integration is very seamless. Before this AO was ever put forward, we really saw this with encampments after Davis was evaded. APD responded to a large encampment on 3rd Avenue, and as they were engaging with those individuals, it wasn't, you must leave it, you can't be in this area, we're seeking compliance, would you like access to shelter? And for those individuals that said yes, APD was able to reach out to Heading, who was able to come provide outreach in real time and get 7 individuals from that encampment into shelter and support. So it's not something that we're creating from scratch. It's something that has developed over time over this last year with our partnerships. The coalition, as well as other partners, have come to the table. As and if the AO passes, we will absolutely operationalize this so that it's very seamless, so that everyone understands what that protocol is. But it would really be, to our providers will recognize this, kind of systematizing what that response looks like that has developed very organically.
All right, thank you. Next, I have in the queue, Mr. Chris Rodriguez, Mr. Johnson, Ms. Rawlings, Mr. Wallace, so Mr. Risky.
Thank you. I have 3 questions. The first one is on cost, the second one is on implementation, and the third is on evaluation. On cost, I just want to get a sense of, there was public testimony around this, there was a lot of concern around this, about how this is going to impact our capacity within our police department, other services, and the overall sort of cost that is going to be related to this. So that's the first question. The second is around implementation. You talked about this a little bit, but when you, as you characterize it, you have a large police force that is, so I want to know about how, whether there's going to be training for all officers in terms of how to implement this new law, and so that there's consistency in terms of how it's implemented in a way that's being characterized to today, and as a deterrent, as a least, as the last thing that you would do. What is going to be the implementation plan to ensure that it's being implemented in the way that you're describing it, and that that's consistent? And then the third question is around evaluation. We recently passed a new law regarding carding folks, right? And very quickly, we changed it because of the implementation, because of the impacts, and for many of us, it was not doing what we're hoping it to do, and we learned a lot from that. So what is the evaluation process that we can come back with some metrics, with some information, some data, to know whether it's actually having the impact and being used as the tool that we're hoping for it to be today? So those are actually the questions.
To the Assembly through the Chair, I'll start with the first one on cost, and then I will turn it to APD to talk about implementation, and then back to Ms. Brown to talk about evaluation. But on cost, I think that's a very good point, and that is something that the administration looked at when we were refining this proposal and areas that we would want to reach to, and what we could do currently with our existing resources, how much geographic area we believe we could enforce with our resources at this time, and then in the out years, how, when this is implemented, will that affect costs not only for APD, but also costs on Parks and Recreation and Healthy Spaces and on our fire department? Because again, what we have seen is that cleanup of these very large camps is highly costly. They are quite a drain on resources. And so this is a way to prevent that out-year cost that will allow us to invest in using those resources in more effective ways. So we took cost into consideration when developing this proposal, and we believe that we can implement it with our current resources at the various departments.
Yeah, the first question. The next question is on implementation.
Through the chair, Mr. President. If this is to become law, we would absolutely put out guidance and training to the officers on how to interact and correspond with folks that for camping calls. And again, the camping calls that they're coming in through dispatch would be categorized by priority. And so that's how they would get assigned. If CAB and MIT are working, they would be grabbing those calls, and outside of that would be patrol. So the guidance and training would be there.
That's the evaluation.
And through the chair. Through the chair. what we would do is, if this were to pass, we would set up an evaluation process that would include APD, the data collected by APD, as well as our outreach partners, so that we would have some key metrics that we could establish over the initial implementation period, and then have set milestones that we could report back to the body, so that we've got just kind of clear understanding and buy-in on, are we seeing the impact that we anticipated? And that would be moving people along in some of these critical areas that have been identified, and then how has that worked in partnership with our ongoing abatement protocols?
Thank you. Just a closing statement, and I'll let someone else get in the queue. Yeah, in terms of the evaluation, I think that I'm interested in that because I'm interested in how we measure deterrent and how we measure prevention and how we measure these things that we're hoping for it to do. And so I am really interested in that, and whether that needs to be in the proposal itself or whether those are things that we will follow up on later. But thanks for the answer to the questions.
And if I may, Mr. Chair, to go back on evaluation, we are not inventing the wheel here. Other communities have taken a similar approach, as the mayor described in her opening comments, and so we are looking at those models for evaluation as well. And then on costs, two other factors are the repeated costs that we are currently incurring through both AFD and APD to go back and go back and go back to long-term camps, and the amount of time that it takes coordinated through both the mayor's office and the attorney's office and APD and the health department to currently get to our abatement state decisions. So, there is a cost that will be avoided on that as well. And then lastly, our municipal manager has frequently reminded us the cost of M&O on places like the snow dump and improvements that we have had to make to places like that, both for cleanup, but also just to provide a basic level of safety for our operators that are at those sites, but also for the people that have camped there. And so I don't know if you want to give the example at Davis of the improvements that we had to make there to ensure safety.
Happily just raise Mr. Chair, members of the chair. What Jeff was noting is the investment we made in lighting at the snow dump at one point, because of the fact that we were experiencing interactions with campers and our heavy equipment that utilizes that site. So that's one of the reasons that those sites are particularly dangerous for camping, and it's just an example of the way in which we have invested resources over time, not simply in camp abatement, but also in management of large encampments that are on municipal property, and some of the avoided costs that we might anticipate from utilizing this tool for those sensitive areas.
Okay, I'm not going to jump the queue. I have a question for the
Yeah, maybe two questions. I'll try to keep quick. First, the municipal prosecutor's office. You guys mentioned that the expectation is that citations would likely be rare, and then there's people have good process rights, and then ultimately there's the possibility of conviction, in which case there would be misdemeanor. I understand it's a judge who actually makes the determination of what the sentencing should be, and I think we are mostly aware that misdemeanor being up to a year of incarceration. Can you say what you see as sort of more typical sentencing, actual sentences that are handed down for A or B or so?
Thank you. A question for the chair. In thinking about the other types of crimes we prosecute and that typical offers would make, it's likely that a first-time offender, if you will, with no prior history of crime in the municipality or elsewhere, we'd be looking at something that maybe involves some suspended time. That is, stay in compliance with the law, don't go back to where you're supposed to be. And we hold that suspended time in case they reoffend. Somebody who refuses and gets a citation for failure to follow the order to leave, etc. Maybe we would expect and hope the judge would give them some jail time, a few days, right? So not unlike first-time OUI, where the minimum on our offers is usually around 3 days of jail time with some suspended time on top of that. So we're not looking at 1 year, we're not looking at months, we're not even necessarily looking at weeks. That's have a lot of prior history where a few days in this compliance.
Okay, thank you. And my second question to AG, it was sort of asked earlier, why do we need a law if the goal is compliance? But as I understand it, unless there's a legal prohibition on some conduct, you can't actually expect or demand compliance, right? A law enforcement officer can't tell me not to do something if it is illegal for me to do so, right?
Through the chair, Mr. Johnston, absolutely. I think it's best probably told in a story a little bit about the Davis Park abatement. Outreach efforts went in well before we ever started the civil abatement process, and we got some people to go into housing. Day of abatement, got more people to go into housing. Several people moved to another location where we had interaction with them, and then when we had interaction saying you can't be here either, they're like, all right, fine, I'll take some resources. So having a end state there definitely showed some incentive in that case.
Thank you.
Thanks. I have a few questions. They mostly circle on the map, but I'll start with a separate one. On page 4, this is in, I'm referring to the S2, but it's in the S1 as well. Page 4, lines 7 to 9, there's two circumstances that would make something a Class A misdemeanor instead of a Class B. The first Class A has a steeper penalty. So I'm going to quote the second circumstance is what my question is. Where a person is in violation of the section and refuses to immediately comply with a warning from someone with apparent authority, the violation is a Class A misdemeanor. So I want to know, what does apparent authority mean? Why does that not say something like peace officer? Why does it say immediately comply? And in a circumstance where someone, for example, is being oppositional, does this mean that they are automatically punished more?
Through the chair, Member Brawley, thank you for the question. That language refers to, so the language of apparent authority is drawn from the existing trespass prohibition, which says that if someone with apparent authority tells you that this area is closed or you can't be here, that triggers the trespass prohibition, and then you can be punished if you're in the area. So it's standard language drawn from that existing statute. I think the intent reads to sweep farther than APD. If someone else from the municipality with apparent authority, if the parks director comes to someone and says, you can't be here because this is playground, that should be good enough. You shouldn't have to also have APD there. Now, in practice, I imagine in almost all these circumstances, it actually would be APD out there in the field, but the intent here was to grab that pre-existing, I think, long-standing legislative language. And I apologize, I've now forgotten the second part of your question. Oh, I'm sorry, immediate compliance, right. So the goal here, again, is to give people incentives to not become confrontational. So when someone says, you are 30 feet from a highway, you need to start packing up now. This is a criminal violation. You're underneath a bridge. You're in the trail. You have to go now. We want to give someone the incentive to really listen, to really hear, and to really start complying. Now, we are not saying that if you don't have your camp packed up the next minute, that's a Class A criminal misdemeanor. The intent here is just a reasonableness standard. You have to start immediately complying, but the standard is going to be what's reasonably possible under the circumstances, taking into account, what's in the camp and the person's physical and actually mental health and condition. And again, my understanding, I would ask my friends from the UP to extend this answer, but my understanding is that people at MIT or the Hope team are highly trained in how to interact with people and try to obtain compliance in these especially volatile situations.
I'm not sure there's much to add through the chair to Senator Brawley, but we talked about this several times. We are looking for compliance and reasonableness based on the situation. So again, I think our standards, when we give a warning, it's not going to be more than 24 hours. But it's what's reasonable. And again, a backpack and a tent, that seems reasonable to pack up relatively quickly versus if there's other items there that they need to make trips or something along those lines. So.
Thanks. I guess just a quick follow-up there. So, and I'm not at all asking because I want this authority or I intend to exercise it. Would an assembly member be considered having apparent authority if I saw somebody camping next to a school? Would somebody who is volunteering with the Parks Department, a volunteer, not a municipal employee, would they be considered to have apparent authority if they are leading a volunteer team? I want to make sure I understand the edges of this and whether it could ever apply to somebody who's not a municipal employee.
Through the chair, Member Rowley, Those are questions I hadn't considered until you asked them. I'm not sure I'm going to give you a definitive answer just off the cuff or happy to do so and continue our discussion potentially one-on-one. I do think that someone who's not actually an employer or officer of municipality clearly would not have a parent authority, so I think that's a pretty easy answer. And then I think a parent authority would likely depend on someone's status in the hierarchy. Like, again, the director of Parks and Rec, I don't think there should be any question if that person has a parent authority to tell someone definitively, this is a municipal playground, you cannot be here. And I'm happy to extend that conversation with you once I have a chance to think it through a little more. Thank you.
Yeah, I just want to register concern about potential misuse of this, and especially in the moment if somebody seems to pretend that they have authority and they do not, and then they misuse the statute or this ordinance. My other question is, I'll keep them brief, but really just wanted to highlight the protected land uses. I understand that. I've been around long enough to know several of the fights that have occurred with those around alcohol licenses, around marijuana licenses, measuring distances. So I'm going to submit some of those questions in writing, but I'll just highlight a couple. One is definition of school. I know that's been a long-standing issue, and I see on the map that's provided that it's just illustrative. It does not include a number of schools because there is an ASD facility, and then there is the school down the street from where I used to live on Wisconsin Avenue. There is the ASD testing facilities. There's a number of other facilities that are not represented on this map and need to be included because that is part of the definition. I also want to just flag straight line distance in marijuana licensing. We use the standard of a shortest practicable pedestrian route. So we measure so that it's actually shorter than what the straight line distance would be. So I guess my question would be, did you consider that practical pedestrian route, and why are we applying a more lenient standard to a business versus a camp location?
Through the chair, Member Brownlee, I actually don't think we are applying a more lenient standard, and maybe I've misunderstood what you just outlined is the case in another circumstance. But here, the straight line distance, I think, is more strict. We're saying if you're within, for example, 500 feet of that playground boundary, then that is a violation of the AO. It doesn't matter what the walking route would be to get there. So it's just a 500-foot buffer all the way around that piece of property. I think that's the most protective way of drafting it, unless I misunderstood an alternative.
Yeah. I guess I'm just pointing out the inconsistency of saying that in practice, a marijuana business, for example, can be less than a straight line 500-foot distance or 200-foot distance because it is measuring pedestrian route, which could include fences, crossing the street, et cetera, versus this. So I'm going to submit those other questions in writing because I want not to take up too much time. My last question, and a couple others have brought this up, is really around the map generally. I know Mr. McCormick mentioned this doesn't really show private property. I know that if you are on private property without the owner's permission, that's trespassing. So practically speaking, there's much larger portions of this map that are off limits outside of the scope of this ordinance with current law. And then my other question is the definition of public land doesn't include federal land. And I have to assume that deals with enforcement, but what this seems to say, and I wonder if this is your intent, is the intent that we're essentially saying go on federal land. For example, BLM Campbell Tract. Thanks.
No, so through the chair to Member Brownlee, the intent is not to tell people to go on any particular piece of property. The intent here is to define these very sensitive areas where we know no one should ever be like a children's playground, a children's athletic field, school grounds, on the trails, right next to a high-speed road. That is the intent of this ordinance, to obtain swift compliance for people not camping in those areas and to prevent entrenched in camping.
Yeah, and I understand the intent of that. I guess my questions continue to circle around, in practicality, then what is the step to, where are the places that would be less enforced, essentially? And I know that we can take that offline, but that's really what I'm seeing on the map and the limitations of what you provided.
All right, so I'm going to ask members to be prepared to stay an extra 10 minutes because there are a number of questions and we're not quite through the list. So we're down to 5 minutes to the scheduled end. I think 15 or 20 minutes we can get all done. Mr. Bond.
Thank you, Mr. Chair. I don't know if I would be able to say how long I have a patient schedule at 2, so I'll have to leave probably right at 2. So I want to bring this back to Davis Park because that's, I think the biggest example of why I think we do need something like this, because I think that we have seen non-compliance. In fact, we saw a notice abatement process, folks light fires in the woods in protest. I mean, that to me is the epitome of non-compliance. Am I correct in my understanding that those were campers who started those fires? I don't know who else to take it.
Deputy the Chair. Member Holland, so we don't have any, we have some leads, so I don't want to disclose too much about the investigation, but we have concerns that it could be some of the campers.
Okay, concerns that could be some of the campers. I think I've had a different context for this whole conversation than most of my colleagues have. Earlier, it was framed as service provider integration with lead deposit outcomes. We've had service providers going out to Davis Park for a substantial amount of time, is that correct? Okay, and still, we saw the outcome that was described with trash, with fires being lit, potentially in protest, and maybe we're investigating that. We've also had for months in Mountain View, I think I've had sort of an interesting dynamic that maybe my colleagues haven't experienced with their community councils, where we've had campers from Mountain View coming to Mountain View community councils, boldly asserting they have a right to remain either in Davis Camp or the snow dump. Does that match the administration's recollection or experience? I'm getting a head nod from Ms. Brown.
Yes.
Thanks, sir.
And I'm also getting head nods from APD. So clearly, we have a group of folks who feel entitled to camp indefinitely on public land, municipally owned or otherwise. It was described in the mayor's opening remarks that we had about 50 people who were, during the Davis Park abatement process, moved into housing or shelter, and that is fantastic, and that is the best possible outcome. How many folks were offered services during the abatement process who chose not to avail themselves?
Through the chair, Member Rowland, we do not have a definitive count of how many people got services.
Do we have an estimate? Do we have a ballpark?
I do not, but I can follow up with that information.
Were there folks who were offered housing or shelter who said no or decided to go somewhere else and not take up those opportunities?
That is correct, yes.
Okay, thanks. I think that answers all my questions. Thank you, Mr. Chair.
Thank you. Next, Mr. Griffin.
Thank you, Mr. Chair. I just want to say, first and foremost, I appreciate the conversation we've had about pretrial diversion and therapeutic courts. To me, that's the most important part of this entire process. That's why I think the original was so good. I think that's why aspects of the S-curve are also very good. But my question, I want to circle back to something Member McCormick touched on briefly. This is for legal. So enforcement is based on resources that are available. So why would we not include distances to residential zones to have that resource available for quick and swift removal of camps through the bid process instead of just purely through the civil abatement process?
Through the chair to Member Berger, thank you for the question. I think I'd have to defer to the policymakers when we take it. There's always line drawing. Lines to be drawn in any attempt, to create a new crime and decide on what areas should this crime be applied. And our focus in drafting the S1 and S2 versions was to focus on those areas where we see the most troubling sets of interactions and the biggest threats to public health and safety. And I think just to name some camps just to illustrate the point, Lotus and Benson, right next to high-speed roads, large amounts of community concern for months, and it took too long to be able to abate under our civil code, right? First we had to get permission from DOT, then we had the 10-day waiting period, then we had the cleanup period. If this draft AO had been in place when those camps started showing up, we could have used the possibility of swift criminal punishment to get those people to block much faster and give a much better response to the community. Now, we have not seen similar levels of concern for serious public health and safety issues outside of these specific designated areas identified in the S1 and S2 versions.
I guess more.
And then, sorry, if I could just extend the answer, I think I mentioned this earlier, this is really a crucial point. If we can prevent the entrenchment of camps and get more efficient self-compliance in these priority zones, we can more efficiently deploy our existing other tools like civil abatement in other areas, also more efficiently get people connected with services using those other tools.
Yeah, and I really appreciate that. I guess just more succinctly though, there's not a legal barrier or legal standard that would prevent an amendment perhaps to include distance to residential zones?
Through the chair, Member Berger, I think I would defer to a potential confidential attorney-client conversation about legal risks associated with any potential amendments, and I would welcome those conversations.
Thank you. I wrote in the queue, but I've already spoken, so we'll get to Ms. Bonneville and Ms. Silverstone.
Thank you, Chair. For anyone in the administration, what is the working definition of an entrenched camp? Is that a duration? Is that a number of people? What does that actually mean?
So that's not a phrase that appears in legislative text here, and so it's not a defined term. The policy goal was to prevent entrenchment. So I can just say that the common sense understanding there is when encampments remain in a specific location for a long time and more people join, the harms to public safety and public health increase exponentially, and the cost to the public of cleaning up those camps increase exponentially. We see the biggest threats in the calls for service from APD to those camps that have been there for quite a long time. People are trying to build the kinds of structures that this area would prohibit.
May I ask, how many camps that the administration is currently aware of fall into this umbrella, or fall into the umbrella of what you would consider an entrenched? How many exist right now?
I think through the chair, again, we stated that we have abated 28 camps. I believe we would consider those 28 to have been entrenched. That does not mean that there are not camps that are still persisting of a large proportion or that will have a significant cost of cleanup and may include large structures that this AO will prevent, but I will also turn to Ms. Brown to follow up on that.
Through the chairman for Baldwin, I think it's also important to have context is prior to the administration, there was the Supreme Court ruling that did not allow for swift abatement, and it actually halted abatement. So unfortunately, our community experienced a number of encampments that had the ability to thrive, to be there for a significant period of time, and for many individuals to be there. One encampment that I will just remind everyone was an encampment off of Fireweed at Alsco. We had a number of complaints about that camp when we spoke to the owners at Alsco and to the folks at the school. It had been there more than 2 years, and specifically.
Sorry, Ms. Brown, I don't mean to interrupt you. I was just curious about how many camps we would currently say that are existent in this moment. I totally understand what an entrenched camp looks like. I'm just curious how many of those we currently have in Anchorage that have been identified as entrenched outright up.
Again, I think as the municipal.
And the answer is no, there aren't any. That's okay.
No, I think the answer is we do not have a full inventory of them, but they grow quickly.
Sure.
So it does not, you can go by the camp on C Street as you are heading south towards Fireweed, the camp that had been abated and regrew very quickly and became a significant safety problem, not only for the people that were living there and literally were sprawling onto the sidewalk, but also for, the school kids, for the children that no longer had access to that sidewalk. That quickly became a significant camp that now has to be abated. So it is a perpetual existence of large, significant camps that this AO is meant to address.
Let me ask a question then. So I'd love to understand why 8.45010A 3 and 4 criminal trespass is not applicable in any of these situations, because the way that section of code reads is that criminal trespass applies when someone knowingly enters or remains on public premises or property or in a public vehicle when the premises, property, or vehicle is not open to the public, or after the person has been requested to leave by someone with the apparent authority to do so, which Mr. Husa alluded to earlier. That's number 3. And so that is public premises or property. And then there is the fourth clause, which says that knowingly enters or remains on undeveloped public or private property in violation of a prominently posted notice against trespass, when the person has had other actual or constructive notice that the property is not open to the person, or after the person has been requested to leave by someone with the apparent authority to do so. So what I'd like to understand is why is that code that we already have insufficient? Because each of those has, after the person has been requested to leave by someone with the authority to do so, as an or clause, not an and, but an or. How is that insufficient to do exactly what we are proposing with code that we already have? And if it is insufficient, then how is that, like, why do we have it if it's unenforceable?
Through the chair, Member Baldwin Day, thank you for the question. That is another important tool in the toolkit, the trespass code. But as you notice when you're reading the code, there are a number of requirements that won't always be easy to apply. So for example, the prominence of the posted notice might be debatable in some circumstances, right? Well, there's a sign over there, but not here. What do you do with those circumstances?
Sure, but that's an or. Like it's the violation notice, there's an or. It's not this and also this. Like it is knowingly enters or remains on undeveloped public or private property. C, because both clauses antecedent are or, after the person has been requested to leave by someone with the apparent authority to do so. And I would assume that an APD officer is someone with the apparent authority to do so. And I'm really struggling with this idea that we are creating duplicative code when we have something that allows us the latitude to do exactly what the administration is proposing without creating this. And I'm really struggling with that as a policymaker, to be quite honest. Because I share the concerns of my colleagues that have been expressed around implementation, around cost, around staffing. And if we already have code, we already have criminal code that speaks to this, then why aren't we using it?
Through the chair to Member Baldwin Day, I'd like to have a further conversation with you about this, but I think that the high-level answer is this draft AO provides significantly greater clarity about exactly what is prohibited and where you cannot be, where enforcement is going to be part of it, right? So if you are right that APD officers could, in certain circumstances, come and tell a person, I have apparent authority, you're not allowed to be here. But if the code itself is telling you everyone, playgrounds, schools, this close to a high-speed road, you cannot be here, and these are the very significant penalties, we anticipate that will have a greater effect in self-compliance. And I would request a further conversation on that.
Yeah, I would appreciate that. And then the last thing I want to just clarify that I heard correctly, that with respect to enforcement and integration of public services and behavioral health, there's no guarantee that shelter or other legal option will be available upon enforcement of this AO.
I will have Ms. Brown tackle that question.
I think that's what I heard. I just want to be sure that this is exactly what I heard. There is no guarantee that shelter or other legal option will be available under this AO.
Through the chair, Member Baldwin Day, that is correct. There's no guarantee of shelter.
Thank you.
Thanks. Ms. Silvers and myself, and we'll be wrapping up.
I just wanted to highlight one of the whereas statements. Sends a clear message to the community that such unsafe and inappropriate activities will not be tolerated. And for me, I think that is the key to this ordinance. Public safety matters. We have 290,000 people in this municipality that we need to provide public safety for. And I think that, this is important in that it says that camping by and leaving needles around the playground is never okay. I think it's important in that it says building structures and starting fire to them in protest is never okay. It says aggressively protecting your camps if they're near a school or a playground is never okay. And so I think for me that is really key. And so I guess I don't have a question in that. I just wanted to make that statement. I do also think that there is always a legal alternative with the S2, whereas the original version did not provide a legal alternative. So a legal alternative would be someplace that is not covered in the distances. Is that correct?
Mr. Chair, are we debating? Yeah, it is a little bit close to that line, but that's a question, and the question is fair. The question being, is there an alternative that's lawfully provided by this, or through this process? Fair question.
Through the chair, under Silver's, this draft, S2, targets very specific zones with the highest need. There's where we see the highest calls for service, the biggest threats to public health and safety. And that's the intent, is to cover that. It leaves untouched the rest of our code that addresses camping more generally. And we can still use our civil abatement process, our other efforts, our other tools in other areas, and we can do so more efficiently.
So I think that the answer is there are still a lot that we just heard about trespassing and other variables that make it so that it's not an alternative. Okay, so I just have a few things to point out, and I guess we've done those wants to speak up. There was an assertion made about the epitome of non-compliance was the people lighting the fires in the camp in Davis Park, which really makes me mad too, but I want to know, is it currently a crime to light fires in parks to set them on fire?
Yes, Mr. Chair. So the Assembly recently passed an ordinance prohibiting burning that would apply to that.
Right, but beyond that, a fire to keep warm, like if you're setting a fire to threaten or defend land in a public space that you don't have possession of, there's already other state, local laws that address that, right?
I believe that's why APD is looking at the situation.
Right, that's arson, right? So there's no notion that this solves that problem. That problem is solvable under the current law, I believe, if we can find the people who did. And that being the challenge of this. Okay, so there was an assertion made that cost avoidance is one of the reasons to do this, because APD and the other municipal teams are going back and back and back. But we now recognize that there isn't an actual proposed place for people to go where they don't have kind of the same conditions that exist. That might exist. There might be a place in the treatment opportunity, a shelter, or a housing, but we know that there's a limitation on that. So if then the question is, we let this camp get to a point of scale and then we have to break it up because it's too big, which I don't necessarily disagree with, that's not really cost avoidance, is it, to just then say you must move to some other place? Because the cost is going to associate with the people creating the challenge, isn't it? If we don't solve the challenge, then we don't solve the cost.
Through the chair, I think the premise is though that the camps will not get to a significant size, like a Davis, like a Lois, where you have an accumulation of stuff that then costs mostly Parks and Rec to remove all of that material. Plus, like we saw at Davis Park, the additional APD officers that are assigned, the fire department that is assigned. I'm sure you do. I will finish in a second here. But I think, again, it is the accumulation of materials at particular sites. We saw people leaving Davis Park with multiple propane tanks. And that is what we are, through compliance, reducing here. That will be a cost savings to municipal operations.
So let me ask my next question. So you mentioned a camp at C Street Fire that was abated and repopulated. Do you remember when it started to be repopulated?
I don't. I did not mark it on my calendar at that time.
Like since Davis,
it was pre-Davis.
Right. So currently under the code, within 10 days, it could be noticed and abated. So I just want to point out then that even that example is currently capturable under the current law. So I think though that the part of this law that is most interesting to me and least offensive is the structures piece, right? Because that is an issue of safety, it's an issue of the biggest materials coming in. But this idea that this provides us an opportunity that we don't currently have when we aren't already at the fore, on the leading edge, like noticing it on the first day. So in 10 days, we can come back with our efficient teams and make it out of it. It's telling me that we're not quite to the point, which brings me to my next point, that it's all about the resources, right? In the end, it's all about the resources. And so I think that the answer to this problem comes when we have teams stood up from the police, the CSOs, and all of those other resources coming into play, where we actually will be able to implement the laws that we have. But currently, we're not really implementing the laws we have, are we?
Well, through the chair, I would say we are implementing the laws that we have, and in that example, if you look at the course of 10 days that it would take us to have authority to abate that camp, there is again an accumulation of material. There is a sprawling of that site. Even within 10 days, you can let 3 days go by and you will see the significant increase in a camp that we are not currently able to abate, but we would be able to abate very quickly under this new AO. This new AO is going to accelerate intervention at particular sites so that we can reduce the impact on our public safety, reduce the impact on children walking to school, reduce the impact on our current APD, health department, fire department resources. And I think it is also important to remember that if we had our full force at APD, we would still want to use them as efficiently as possible.
Absolutely.
Even if we were fully.
I don't disagree. And if the camp was there that you noticed, you pointed out as a good example, because there before the status has been a month or so. And so a month has gone by and we haven't even noticed that camp. So it did not yet rise up to the level of we're ready to do this. And so that again raises to me a consideration. Finally, my last point I'm going to make, I want to ask this question. Dennis, you use an example that raises the skin on the back of my neck a little bit. You raised the example of an OUI in correlation to being cited for camp. And so, was that really your intent?
Mr. Chairman and side members, the intent was just to give you a general sense of where our typical offers are the sentencing of land. It's not meant to make any other correlation between the OUI and camp. Just to give you a sense that typically in our sentencing process, we're not talking about 1 year for Class A use, even though that's the potential. We're always talking about something substantially less, whether that's camping or OUI or trespass or DV assault or regular assault or harassment. Basically, most of our sentencing is not meant to try to max out the penalty. Similar to other arguments about pretrial diversions, it's really looking at how do we best get compliance. It's not always about throwing the maximum amount of time. It's like, or would the judges normally give that, unless there's very unique special circumstances, including lots and lots of projects.
Right, so last part of that question, you've got lots of experience as a prosecutor and been to the courts. How hard is it for a prosecutor to get an indictment on OUI?
Mr. Chairman, we don't use indictments per se, we use information.
At the local level.
But the point is, typically, police officers develop a case, collect the evidence. Typically, that involves, assuming the person doesn't refuse, they go through the data master, they have a blood result, we review that case, assuming all those elements are met, we will file the information and prosecute the case.
Almost in every single case, if the jury's involved, if the grand jury, an OUI will get an indictment. That is like, they say all it takes, you can indict a ham sandwich, but it's true in the case when you talk about an OUI. And I know that's the felony level, because we don't do indictments, that's the state, but I am concerned that even in this work session, we're having just kind of rhetoric that connects OUI, which that body of law is developed because of the extensive loss of life and people trying to survive in camps. So I have some strong feelings.
So understood, I understand the municipality is not making the connection in the way that you're describing. I was only giving that an example of the typical sentences we may see.
Thank
you. So there are a number of amendments that we haven't had a chance to go through. We are out of time. I asked the members to review that. The public hearing on this item will be set again for 1 o'clock on Friday at Assembly Chambers. We'll go till we're done. There's an anticipated executive session to be briefed by the Department of Law on kind of the various liability issues surrounding these matters that are before us. We'll take all public testimony before we move into an executive session, and the body will, of course, choose the course of action from there. So I look forward to the lively debate. Ms. Brown?
Through the chair, would just like to make one comment about the resource. I think all of you have at one point, or maybe many, have emailed me about camps in your district that you would like to see deleted. In the example that you gave, it's been a month since Davis, and closed in the for 10 days. That would be true if we weren't also considering the amount of time that it takes to locate camps. And then as we are moving through that list, often exigent circumstances will prioritize the camp over one that we had planned previously. For example, we are going to be moving forward with the camps that are near schools because we're nearing the time that school will be starting. Well, that means a camp that maybe had 10 or 15 people will take us another 30 days to get to that camp, including the 10-day notice of abatement. And now those 15 people are now 30 people. And so when we think about being able to move swiftly and quickly, it is being responsive to the community in the areas that we have prioritized, but also managing those resources so that a camp of where it's kind of a micro camp that's maybe 5 or 6 tents doesn't become 15, it doesn't become 30 in the time frame that it takes. And it also, again, allows for that engagement in a much more reasonable way with individuals. But I just wanted to put that in there that, again, if we have the resources to move incredibly quickly, which we don't, but what we do see in real time and in real practice is that it could take us anywhere from 30 days to 2 months to get to a camp, just simply because of the many constraints that we have. This would allow us to move much more swiftly.
Yeah, and what you just talked about, I think, is always maybe the policies, maybe the structures, policies, the criminalization policy is somewhat different. And so it feels like we're having two conversations about two different things. And I have benefited, my neighbors have benefited greatly from the department's effective process for communication. So I will say thank you. My heat on this is just philosophical. Yeah, request before we go.
Yeah, I know we're out of time. Just one request before we go. I think the one piece that I feel we've not resolved is the flexibility from Member Walker Day, is that you've talked about the prevention, you've talked about all the things that this could do, but in terms of the implementation of it, how this is different from what's already in code. And so that I think maybe can come back to us in writing, but I think there needs to be a better explanation about why an officer today couldn't immediately move someone along with the existing code that we have. And so that can come in a different form, but that I don't think is clear to me at this point. I see the other benefits of this and how all of those potentially are a positive thing. That piece, I think, pulled out needs to be answered. Thanks.
Okay, last questions, any last words? No. Again, this will be back for us in the meeting on Friday at Assembly Chambers. Looking forward to the fullness of this conversation. With that, then, thank you to the administration for the very thorough briefing. We'll be back. We are adjourned.
Oh, yeah.
Oh, deputy chief. I could just stay.
I think Ryan's gonna come by.
Oh, do you have?
I told Ryan to come by for it. Because he's so good.
Okay, and then request thank you.
I mean, that's writing.
Yeah. I'm glad we found this. Dude, that's crazy. Yeah, I know. Are you gonna find it? They have these out. I'm not frequently nowadays. Yeah.
Like always, all the information in this video will be in the description down below. Do me a favor, like, share, subscribe, leave me a comment. Let me know what you guys think about this video. If you'd like early access to videos like this and more, the members tab is open and donations are greatly appreciated. And like always, I appreciate each and every one of you. I'll see you guys in the next one. Later.